The law just changed under your feet, and most of you don't even know it happened. Right now, today, as you're reading the same recycled headlines about the same political circus, 10 fundamental gun laws in this country have been rewritten, and the changes are already in effect as of early 2026. Not coming soon, not pending review, done, final, active. And the people who should be screaming this from every platform are either asleep, distracted, or deliberately looking the other way. So let me be the one who tells you the truth. These aren't minor adjustments. These aren't procedural tweaks buried in footnotes. These are 10 concrete, specific constitutional changes that affect how you own a firearm, how you carry it, how you store it inside your own home, and how the law treats you when you use it to save your life. This is the biggest shift in gun rights in decades, and millions of Americans are walking around completely blind to rights they now legally possess. That ends right now. If you've been waiting for someone to actually cut through the noise and give you the unfiltered truth about what's happening to your constitutional rights, you found it. Subscribe to this channel right now. Hit that notification bell. Because this is exactly the kind of reporting that gets buried, ignored, and suppressed while the media chases drama instead of facts. Your rights just expanded. You deserve to know how. Let's get into it. Start with the foundation, because without understanding this first change, none of the others make complete sense. For most of the past 50 years, the legal standard applied to gun laws in this country was embarrassingly weak. Courts operated under a framework that essentially said this: if the government can come up with a halfway plausible reason for restricting your Second Amendment rights, the restriction probably stands. That's it. That was the bar. Not proof. Not hard data. Not measurable evidence that a law actually accomplished anything meaningful. Just a reasonable sounding justification, some talking points about public safety, maybe a press conference with emotional families standing in the background, and courts would nod along and let the restriction pass. For 5 decades, that's how your constitutional rights were managed. Like suggestions, like privileges the government could walk back whenever the political wind shifted. That system is finished. The November ruling from the Supreme Court establishes, explicitly and without ambiguity, that every gun law in the United States, federal, state, county, municipal, every single one, must now survive strict scrutiny. And if you think that's just legal jargon that doesn't affect your daily life, you need to understand what those 2 words actually mean, because they are the most powerful legal weapon gun owners have ever been handed in the modern era. Strict scrutiny means the government can no longer waltz into a courtroom with feelings and political pressure and walk out with a restriction on your constitutional rights. They have to prove, with actual empirical evidence, with verifiable data, with facts that hold up under real examination, that they have a compelling governmental interest in limiting your rights. And that's only the first hurdle. They also have to demonstrate that their law is the narrowest possible restriction necessary to achieve that interest. Not broad, not convenient, narrowly tailored. And they have to show that no less restrictive alternative exists that could achieve the same goal. All 3, simultaneously, every time, or the law gets struck down. Think hard about what this reversal actually means for the real world. Thousands of gun laws currently on the books across this country were passed under the old weak standard. Magazine capacity limits, mandatory waiting periods, bans on specific cosmetic features of rifles that don't actually affect function, permit requirements just to purchase a firearm in the first place. All of these were approved by courts that asked nothing more than a rational basis, a reasonable sounding excuse. Those laws are now legally vulnerable in a way they have never been before. If a state cannot produce hard empirical evidence that banning a 15-round magazine produces a measurable reduction in violent crime, that ban is now challengeable and likely to fall. If they cannot demonstrate that a 10-day waiting period is the absolute minimum necessary restriction and that nothing less intrusive would work, it goes. This is 50 years of incremental erosion finally being reversed. Gun owners now have the legal tools to fight back against restrictions that were never based on evidence to begin with. Everything that follows builds on this foundation. Now talk about the change that could save you from something almost as devastating as physical violence: total financial destruction. Because here's a scenario that has played out in this country over and over again and should make every law-abiding gun owner furious. You're asleep in your home. It's the middle of the night. Glass shatters, footsteps in the hallway. Every instinct in your body fires at once. You grab your firearm, you confront the intruder, and you survive. Law enforcement investigates, reviews the facts, and concludes that you acted in self-defense. No criminal charges, no arrest. The system says you were justified, and then, just when you think the nightmare is finally behind you, a lawyer shows up with a lawsuit. Not from the state, not from prosecutors, from the person who attacked you, or from their family. And suddenly you're not just a survivor, you're a defendant. Your home, your savings, your retirement, everything you've built is on the table because you refuse to let someone hurt you. These aren't hypothetical horror stories invented to scare people. These are documented, real, and stomach-turning cases that happen to real Americans. A man in Ohio shot a burglar breaking into his home at 2 in the morning. Local law enforcement cleared him completely. No criminal charges, no question of guilt, just a justified defensive shooting. And then the burglar's family hired a lawyer and sued him in civil court. They won. $400,000. The family of a criminal who broke into someone's home at 2 in the morning walked away with $400,000 from the man whose home was violated. In California, a woman defended herself in a parking lot from a physical attacker. She fought back, she survived, and she was sued for $1.2 million on the grounds that she used excessive force. $1.2 million. For surviving. This is what the legal system was allowing to happen. You could do absolutely everything right, be completely cleared criminally, and still lose your entire financial life because some attorney convinced a jury that you could have done more to avoid defending yourself. That legal trap has been abolished. The ruling establishes absolute civil immunity for any use of force that is legally justified under self-defense law. If you use a firearm to protect yourself and your actions are lawful, you are shielded completely from civil litigation. The attacker cannot sue you. The family cannot sue you. No civil case can even be initiated unless the opposing party first proves in a criminal proceeding that your use of force was unlawful. If they can't clear that bar, and if you were truly justified they can't, no civil lawsuit moves forward. Your home stays yours. Your savings stay yours. Your children's future stays yours. For the first time in modern American law, the legal system is actually protecting people who protect themselves. While we're on the subject of protection and accountability, let's talk about something that should have been fixed a long time ago. What happens when it's law enforcement that violates your constitutional rights? For decades, there has existed a legal doctrine called qualified immunity, and it was, quite simply, one of the most corrosive protections ever written into American law. The concept was this: unless there was already a court case with nearly identical facts proving that a specific officer action was unconstitutional, that officer could not be held personally liable for violating your rights. Not the department, not the city. The officer personally was insulated from consequences even when their conduct was clearly and obviously wrong. The doctrine didn't ask whether the violation was real. It asked whether someone had already been violated in exactly the same way before. And if the answer was no, the officer walked. That shield, as it applied to Second Amendment violations, has now been shattered. The ruling makes it unambiguous. If a law enforcement officer violates your clearly established gun rights, they can now be held personally accountable. An officer who unlawfully seizes a legally owned firearm, arrests someone for carrying when they have every legal right to do so, or violates your Second Amendment rights in any manner that any reasonable officer should have known was unconstitutional. That officer can be sued directly, out of their own pocket, not a fund the department quietly pays into, not the taxpayers absorbing the cost while the officer faces zero personal consequence. The officer This is already producing results. In Virginia, a man with a valid concealed carry permit was pulled over, disclosed that he was armed exactly as required by law, complied with every instruction, and had his firearm confiscated anyway with zero legal justification. He took it to court. The judge didn't just rule in his favor. The court awarded $300,000 in damages charged directly to that officer personally. That is accountability. That is what the Second Amendment looks like when it has real teeth. Now let's expose one of the most dishonest games state governments have played with gun rights in recent years. The sensitive places scheme. After courts made clear that Americans have a constitutional right to carry firearms in public, certain states couldn't issue an outright ban without immediately losing in court. So instead, they built walls. They created sprawling lists of locations where firearms were suddenly prohibited. Not based on any objective security standard, not based on actual physical measures that made those places more secure. Based on signs. Based on legislative decisions to designate every remotely public location as a place where your rights didn't apply. Parks, libraries, grocery stores, parking lots, public sidewalks in some jurisdictions. New York and California and New Jersey crafted lists with over 50 categories of so-called sensitive places, creating a geography of prohibition so dense that carrying a firearm legally meant you had almost nowhere legitimate to actually carry it. It was a backdoor ban with a clean public face. The Supreme Court's new standard demolishes this scheme entirely. A sensitive place must now have actual, objective security infrastructure, metal detectors, armed security personnel, controlled access points. A courthouse that screens everyone who enters, a secured government building with real enforcement mechanisms. Those qualify. A park with a sign on a post does not. A mall that decided to prohibit firearms without any actual security presence does not qualify. States are already being forced to slash their sensitive places lists by as much as 80% because they simply cannot meet the new legal threshold. Here's something that should never have required a federal court ruling to fix, but apparently did. The deliberate weaponization of bureaucratic delay to make constitutional rights functionally inaccessible. For years in states like New York, California, and Massachusetts, getting a concealed carry permit wasn't just difficult. It was designed to be impossible for ordinary people with lives and jobs and families who couldn't spend years navigating a system built to exhaust them. You would submit your application, you would pay your fees, you would complete your training, you would pass your background check, you would do everything the law required of you, and then you would wait. 3 months? 6 months. In certain jurisdictions in New York, applicants waited 18 months or longer with no updates, no timeline, no acknowledgement that their application existed. If you called to follow up, you were given vague non-answers and told to keep waiting. This was not inefficiency. Inefficiency is random and accidental. This was a pattern. This was a strategy. This was bureaucratic attrition, making the process so exhausting, so opaque, and so indefinitely prolonged that people gave up and walked away from rights they were legally entitled to exercise. That is over. Under the new ruling, every state is now operating under a mandatory 60-day deadline from the moment a concealed carry permit application is submitted. Not 60 business days, not 60 days subject to extension at the agency's discretion. 60 calendar days. If the state does not approve or deny the application within that window, the permit is automatically approved by default. The burden is on the government to act, not on the applicant to keep waiting forever. And if they deny the application, they must provide a written explanation with specific, legally defined reasons. Not a form letter, not bureaucratic silence, actual legal justification. The results of this change are already measurable. States that previously took 6 months to process a single application have approved more permits in the past 3 weeks than in the prior 6 months combined. The games are done. The same clarity has now been applied to something even more personal: how you store your firearms in your own home. Several states passed storage laws that, on paper, sounded like they were about safety, but in practice were engineered to make your firearm completely useless when you needed it most. Massachusetts required that ammunition be locked in a separate container from the firearm. California mandated that ammunition be stored in a different room. One county in Illinois required that firearms and ammunition be kept on different floors of the home. Think about what that means at 3 in the morning when someone is inside your house. Your gun is unloaded. The ammunition is locked in another room. You're running through a dark house, fumbling for keys, loading your firearm while an intruder is somewhere nearby. You're praying they give you enough time. That is not safety regulation. That is sabotage disguised as safety regulation. The ruling is unambiguous. Any storage law that prevents immediate access to a firearm in an emergency violates the Second Amendment. You have the right to store your firearms and ammunition in whatever configuration serves your security needs in your own home. The government does not live in your house. They do not get to decide how you protect your family inside it. This is where it gets deeply disturbing because the next change involves something the government has been doing quietly for years in direct violation of federal law. Gun owners were told repeatedly that there is no national gun registry in America, and they were right, because federal law has explicitly prohibited the creation of any system linking specific firearms to specific individuals since 1986. That protection was written into law precisely because the American people understood correctly that a government list of who owns what is a government list of who to target first. The prohibition was clear, the intent was clear, and several states violated it anyway, systematically, for decades, while the federal government looked the other way. California's dealer record of sale system quietly accumulated 20 million records linking names, addresses, and personal information to specific firearms purchased as far back as 1996. 20 million records. Hawaii went further, requiring mandatory registration of every single firearm with local police, including make, model, serial number, and the owner's full personal information. These were not voluntary programs. These were compulsory databases tracking law-abiding gun owners with the same infrastructure used to track criminals. And they existed in open defiance of federal statute. The November ruling did not just acknowledge these systems, it ordered them destroyed. Every state-run database tracking individual gun owners or their specific firearms must be completely dismantled within 180 days. No exceptions, no extensions. And every affected gun owner must receive written notification confirming that their information has been permanently deleted. Some states are already pushing back, claiming law enforcement necessity and public safety justifications. The court left no room for those arguments. Noncompliance means contempt of court charges and escalating daily fines until every record is gone. This is the first real enforceable action against illegal gun registries in modern American history. Your personal information does not belong in a government database. Your firearms are your private property. And now, finally, the law is being enforced as written. The ATF story deserves its own reckoning, because what that agency has been doing to small gun dealers across this country is not aggressive enforcement. It's institutional abuse. For years, the Bureau of Alcohol, Tobacco, Firearms and Explosives used minor administrative errors to revoke federal firearms licenses and destroy small businesses. Not criminal violations, not safety failures, paperwork mistakes. A gun store in Pennsylvania lost its entire license because the owner wrote the wrong year on a single form. One transposed digit. License revoked, business destroyed, livelihood gone. In Texas, a dealer had his license revoked because he used blue ink instead of black on a transfer document. The information was accurate. The background check had been completed properly. Everything that actually mattered had been done correctly. The ink was the wrong color, and the ATF used it to shut him down permanently. This was not happening randomly. This was a documented pattern of regulatory weaponization, targeting dealers the agency wanted eliminated. Small shops, home-based FFL holders, businesses that couldn't afford years of legal warfare against a federal agency with unlimited resources. The ruling ends this abuse cold. The ATF must now prove an actual criminal violation or a serious pattern of negligent behavior before any license can be revoked. Minor errors must be met with a written warning and a genuine opportunity to correct the problem. The playing field has been leveled and the weapon has been taken out of the government's hand. If this investigation is giving you the facts the mainstream media refuses to cover, share this right now. Send it to every gun owner you know. Drop a comment below telling me which of these changes matters most to you personally, because the only way this information reaches people who need it is if you put it in front of them. Hit that like button, subscribe if you haven't already, and let's keep going, because the last two changes may be the most consequential of all. Gun owners who travel have spent years navigating one of the most absurd, constantly shifting legal mazes in American life: concealed carry reciprocity, or more accurately, the lack of it. You had a valid permit in your home state. You crossed a border into a neighboring state, sometimes 20 minutes down the road, and suddenly your permit was legally meaningless. States had reciprocity agreements with some states and not others, and those agreements changed without warning. The only way to stay legally compliant was to constantly check and recheck a patchwork map of recognition agreements that could shift between the time you planned a trip and the time you took it. Miss the update and you were a criminal, not for anything you did, but for crossing a line on a map while legally armed. This was not a system designed to serve law-abiding citizens. It was a system designed to trap them. The ruling establishes a national baseline for concealed carry recognition that changes this reality fundamentally. A valid permit in your home state is now legally recognized in at least 42 other states. No additional applications, no extra fees, no separate hoops to jump through because you happen to live in a different state than where you're traveling. Your Texas permit works in New Mexico. Your Arizona permit works across most of the country. States cannot impose extra restrictions or demand supplemental requirements from out-of-state permit holders. Law enforcement departments in states that previously refused to honor out-of-state permits are already undergoing mandatory retraining. Your Second Amendment right does not end at a state border. It never should have. And now the legal framework finally reflects that basic constitutional reality. And then there is the final change, the one that deals with the absolute worst version of what can happen to a gun owner in this country, and the one that represents the most fundamental shift in how the law treats people who defend themselves. Because for years, homeowners who used lethal force in clear self-defense situations where the facts were not in serious dispute, where it was obvious what happened, still found themselves arrested, charged, and prosecuted. Not acquitted after a short trial. Arrested. Jailed. Dragged through the system for months and years while their lives collapsed around them. A man who shot an armed burglar breaking into his house faced aggravated assault charges and spent 2 years and tens of thousands of dollars in legal fees, proving that he did the right thing. 2 years. For shooting someone who was breaking into his home with a weapon. A woman in Maryland shot her abusive ex-boyfriend after he kicked in her door in direct violation of a restraining order. She survived. She was jailed for 8 months before the case was finally dropped. 8 months for surviving a violent attack in her own home. Think about the psychological devastation of that. You lived through the most terrifying moment of your existence. You protected yourself, and then the system treated you like the criminal. The ruling restructures this completely. If you use a firearm in defense of yourself or your family on your property, the burden of proof now falls entirely on the prosecution. They must prove beyond a reasonable doubt that your actions were not justified self-defense. Not you. Them. If they cannot meet that burden, the case does not proceed. You are not forced to spend years and your entire financial future proving that you had the right to survive. They have to prove you were wrong, and if they can't, you walk. This is the most powerful expansion of castle doctrine protections in modern American history. It is the law finally catching up to basic human decency. These 10 changes, the strict scrutiny standard, civil immunity for lawful self-defense, the end of qualified immunity for Second Amendment violations, the dismantling of fake sensitive places, the 60-day permit mandate, the abolition of emergency blocking storage laws, the destruction of illegal gun registries, the end of ATF administrative abuse, national carry recognition, and the prosecution burden shift in self-defense cases. These are not incremental adjustments. This is the most significant restructuring of gun rights in decades, and it is already in effect. Right now, in 2026, the rules have changed, the balance has shifted, and the only people who won't benefit from these changes are the ones who don't know they exist. That's why you're here. That's why this matters. Subscribe to this channel if you believe Americans deserve the truth about their constitutional rights, without spin, without partisan framing, and without the filter of institutions that have something to lose by telling it straight. Hit that like button, leave a comment, and share this with every gun owner you know. Because knowledge is not just power. In a legal system this consequential, knowledge is protection. You now know what changed. Make sure the people around you do too.